Hi, good afternoon, everyone. I'd like to welcome you to part 2 of Baker McKenzie's Illinois Employer Update presentation. This is a CLE presentation, and I'm Shar Dalton. I am General Counsel of Seco Logistics, and I'm also a member of the ACC Chicago Board of Directors. So just want to thank everyone for dialing into the CLE broadcast today. I'm very excited to listen to it myself. There's a lot of great content, great speakers from Baker McKenzie presenting today. And just thank you so much to Baker McKenzie. Programs like this would not be possible without our sponsor firms. And so just encourage all of you in your in-house counsel roles that when you're seeking outside counsel, please consider Baker McKenzie. Again, just a reminder at the end of the program, we welcome feedback. We're always looking to improve upon our programs and offerings. So at the end of this presentation, please look for the link and take the opportunity to give feedback on the program today. So thank you again, Baker McKenzie, for this presentation, and thank you all for dialing in.
Hi, everyone. On behalf of the entire Chicago team, welcome to our second webinar in the annual Illinois Employer Update webinar series. I'm Anastasia Gerasimovich. I'm a partner in Baker McKenzie's real estate group. As Baker McKenzie liaison with ACC Chicago, I want to thank ACC for our longstanding partnership and for the opportunity to present this week's webinar series. We also appreciate those who were able to join us for part 1 on Tuesday and return for the second session. Before we get started, on the screen, you will see a summary of additional housekeeping notes for today, a few things to call out. Our session today is being recorded. The recording along with the presentation and relevant materials will be provided in a follow-up communication after the program. To ask a question, please use the Q&A button at the bottom of your screen. We will try to respond to your questions during this session, or we would be happy to follow up with you afterwards in case we don't get to your questions during the webinar. As Char noted, CLE for Illinois will be provided by the ACC Chicago, and you will receive your certificate from them via email next week. A CLE code for other states will be shared later in the presentation. Please write it down as you will need it to complete the forms that will be distributed in the post-program communication after this webinar. Lastly, at the end of the webinar, please share your feedback with us in a brief 3-question survey. We value your feedback and aim to continuously improve our value-added offering to you. And now I will turn it over to Brian for speaker introductions.
Thanks so much, Anastasia. And thanks again to everybody for joining us here this afternoon for the second part of our 2021 Illinois Employer Update. On behalf of our entire employment and compensation practice in North America, again, we're excited to welcome you to today's session that's going to focus on compensation and benefit issues, as well as immigration and mobility issues. As Anastasia mentioned, my name is Brian Wydajewski. I am the chair of the Employment and Compensation Practice in Chicago. And I'm thrilled to be delighted by my colleagues, Narendra Acharya, Aimee Soodan, Tulsi Karamchandani, Scott McMillen, Angelique Poret-Kahn, Ginger Partee, John Foerster, and Matt Gorman, and we're really excited to share a number of different updates with you heading into the new year. So very quickly, before we jump into the program, let's just take a brief look at the topics that we're going to discuss today. We're going to start from a compensation and benefits perspective. Look at restrictive covenants in equity compensation awards, and then we're going to do some developments from a global compensation perspective. We'll next turn to the immigration and mobility space, where we're going to cover some COVID-related topics, as well as remote work issues in the immigration space. And then we'll conclude with some policy updates under the Biden administration. So again, we've got a lot of good content that we hope you'll find very helpful to your practice. So with that, let me turn it over to Narendra, who's going to kick off our discussion on restrictive covenants.
Thanks, Brian. So this first topic, even though it's being presented during this compensation webinar, is really a mix of both employment law and compensation issues, because we're going to speak to it in the application of equity awards. And so maybe as a starting point and to level set, we know there's a varying practice of how our clients who issue equity awards treat restrictive covenants. And so, there's some, and I think it's often driven by the geographic location of the issuer. So we typically we'll see California companies not including restrictive covenants, but there's also a fair number that do include what we call US-centric restrictive covenants. And then there's also kind of another group that includes them, but may do some country-specific tailoring, which we can talk about in a bit. But I think we're going to actually do one of our first polling questions, Kelsey, and I don't know if we can get started with that, just to see what this group right now is doing. And so we're just asking you for your company's approach, very generally, do you include them? Do you not include them? Or are you moving away from them? And then there's always the other category. And so, just while we're waiting for the responses on that, we can continue on with this slide. There's different philosophies with including this type of restrictive covenant provision in an agreement. And this could be both non-competition provision and non-solicit, just confidentiality. And so you can see we got the results up on the screen that we almost have an equal split of including them and not including them. And it looks like there's also some movement away from them. And so maybe just to explain maybe why we're seeing such a divergence in practice, if you just ask the compensation or an employment person, what's the ideal, they would probably say, just pick the real senior people you want subject to a non-compete and negotiate it and have a standalone agreement. But, equity awards have always been viewed as, this is a simple way of including the provisions, and we end up capturing, our higher or more senior employees globally. And so in some cases, I think, the language is just included. There's no change from the US-centric language, which may have like a 2-year non-compete, which is going to be difficult to enforce. But the company is well aware of that and just says, this is not really intended to be enforceable. It's a belt and suspenders approach. We do get separate agreements where we need them, but we just feel we're giving these equity awards, which can be quite valuable. And for that reason, we want to include the language. So you've got all the design issues. Do you just include other restrictive covenants that not non-compete? Do you have separate award agreements for maybe your officers and you're only including in that? Where we have equity awards, our common practice is to put country-specific appendices. And so in that, you can either carve out some of those provisions or some of those jurisdictions from their covenants. You could also try to shorten periods and do things to increase the enforceability. Next slide. So the reason we included it as a topic for this year's update was just because we have people more on the compensation side. They may not know that Illinois is actually changing its own rules. So even if you don't have a very global population, you should be aware of these Illinois changes, which will become effective on January 1st. And the changes don't outright ban non-competes, but they do put some income limits. kind of more of a reasonable test of, is there adequate consideration, legitimate business interest? So our employment lawyers could do a whole seminar on these changes. But from an equity perspective, and just looking at equity awards, you should be aware that you can't just repeat what you did in the past. If you included awards and you're based in Illinois or you have Illinois employees, because in order to be enforceable, you now have this 14 calendar day review period, which you need to think about, well, how does that work in the way that awards are accepted? Can I specifically carve that out into the process? There's also been some discussion initially of, if I already have an existing non-compete, do I maybe want to just leave it alone now? And so, does that color my approach of maybe not including it in the new grants and just having some language ratifying existing grants? So there's not, kind of a luxury of a lot of time for planning it out. And the other challenge is the Illinois rules and the guidance that's more detailed, hasn't been issued yet. But I think it's at least worthy of the topic if you do have a lot of Illinois employees. Next slide. So this is just, again, some background for why restrictive covenants may not be enforceable outside the US. And these issues of sometimes you have to pay during the non-compete period. There's also a question of how long is a reasonable non-compete period. And what you'll find is in countries that these provisions are enforceable, a lot of times they'll say stick to 6 months or 9 months, maybe if the person's really senior. You also have just questions of how you define competition. Is it every competitor around the world? It's probably less likely to be enforceable versus a very tailored definition of competition, both geographically and in terms of listing competitors. Next slide. So some other just general comments. The risk of including unenforceable provisions, especially outside the US, is you risk those provisions just being entirely thrown out. And worst case, the entire award agreement being technically unenforceable. What you often see is language, that provides that a court can reform the clause, blue pencil it to the level that it is enforceable. What we're seeing more of is kind of these waterfall provisions that will define, they may have like cascading definitions of, the non-compete period is one year, or it could be 9 months or 6 months. And so there's specific, if one provision is deemed unenforceable, the kind of the next level would arguably apply. From our perspective, the other reason we're not thrilled about including the restrictive covenants in the equity awards is you'll see the theme, that of having these grants being considered parent company grants and really trying to limit local employer involvement. And, that helps from both, the entitlements at termination and acquired rights perspective. And so the more that these restrictive covenants are incorporated, you are kind of creating a slight conflict between that narrative of just the parent company making the grant and not having local involvement. So it's a challenging area, and I know sometimes our clients are kind of stuck in the situation of kind of just implement this, just get this done. But there are some, this year in particular with Illinois, there are kind of some more significant issues to work through. So I think with that, I'm going to turn it over to my colleagues, Angelique and Tulsi, to start talking about some of the specific global developments in the equity comp space.
Thank you, Narendra. So let's start with Australia and some potential favorable changes both from the securities and the tax side. In Australia, equity awards are taxed differently than in the US, in the sense that if an award holder retains their award upon termination of employment, the award will be subject to income tax upon termination rather than when the underlying shares are issued. And the Australian government is proposing to change this and to eliminate cessation of employment as a taxable event, which would simplify the tax treatment of awards in Australia and would generally defer taxation until the underlying shares are issued. So it's a good news. On the securities side, if your company offer equity awards to employees in Australia, you probably rely on one of the exemptions to avoid the need to prepare a prospectus. This means that by relying on this exemption, you still have some disclosure and notification requirements, but it's less burdensome than having to prepare a full-blown prospectus. And the Australian government is also proposing to change this by replacing these exemptions by new exemption that would be easier to satisfy, and certainly for private companies. So the change here is really to make the offer of equity awards to employees in Australia easier. For example, the offer of free shares, such as the restricted stock units, would be able to benefit from a self-executing exemption with no disclosure requirements. On the flip side, there are some inconsistencies in the draft legislation, negatively impacting stock options, for example. And hopefully these inconsistencies will be fixed in the final legislation, the timing of which is uncertain at this time. So it's going to be maybe next year, maybe later. So on that front, stay tuned. Moving on to Canada. Canada, we have a few developments for you. And so to start with the stock option, so in Canada, there's a preferential tax treatment for stock options meeting certain requirements, whereby only 50% of the income at exercise will be subject to income tax. So this is still available. However, it's going to be limited. So what you need to know is that if your company has previously taking this tax advantage treatment into account, it will be now limited to 200,000 Canadian dollars per employee. And how this cap will actually be calculated and how companies will have to track this is a little complicated, but it is an important point, because when you when the cap is exceeded, the company will have notification requirements. The company will have to notify the employees within 30 days of entering into the stock option award agreement to let them know of the non-qualified portion of their stock option versus the qualified portion of their stock option. And we must note also that there are some nuances as to how to determine the date of entering into that stock option award agreement. So not so straightforward. So in terms of this development, it has some downside for the employees, but it actually can be a benefit for companies, because for anything in excess of that cap, you may be able to take a local corporate tax deduction, which may otherwise not be available. So for the second update development from Canada, it's about the salary deferral arrangement rules, or SDA rules. Canada has some onerous non-qualified deferred compensation rules similar to what we have in the US. Under this SDA rules, if a company has the discretion to settle equity in cash, and the payout date may be later than 3 years from the end of the year in which the award is earned, then this award will be taxed at grant, which is something that's usually not, the employees are generally not happy about. and which can create also some challenges for companies in terms of tax withholding and reporting obligations. To address this issue in Canada, many companies have specifically included in their equity awards agreement a provision stating that the awards can only be settled in shares and not in cash. On the other side, in Canada, if you want to be able to claim for a local corporate tax deduction, you need to keep the discretion to settle your awards in cash or in shares. So clearly, there's a little conflict here. And to further muddy the water, the Canadian Tax Authority recently issued a technical interpretation in which they concluded that awards granted under a plan that provides for discretion to settle in cash or in share should be subject to the salary deferral arrangement rules. I'm sorry, somebody. So in that case, it would be taxable at grant. And there's also some concern about how to determine that 3-year period. And it looks like the Canadian Tax Authority may actually have some different views, and they may look back at the year prior to the year in which an award is granted to calculate that 3-year period. So what's the takeaway here is that if you are going to look at wanting to take a local tax deduction, you should be mindful of all the implications, and you should make sure to coordinate internally about the terms of the awards and the length of the vesting period, because you don't want to end up with an award that's taxable at grant. But if you want to mitigate that risk, like we said, there's one way to do that. It would be to make it very clear in the award documentation that the awards can only be settled in shares. But however, we want to say that it's still not entirely certain that this is foolproof. And I'm going to pass it on to Tulsi to continue on the Canada section.
Thanks, Angelique. We're just going to continue here in Canada. There has been another development in Canada that's related to employee entitlements after termination. And just by way of a brief background, in certain jurisdictions, there may be a quote unquote statutory notice period or a garden leave period during which employees are continued to be entitled to certain benefits even after termination. And Canada does have a statutory notice period kind of on the books. And the way the landscape is now, it's been a little bit unclear of whether stock-based compensation would qualify as a benefit that would be continued even after termination. And so there was a case recently in the trial court that found that the stock award agreement, which included termination provisions that said the employee would not be entitled to the unvested stock awards, the court found that no, in fact, the employee would be entitled to those unvested stock awards even after termination. And the court ruled that termination provision unenforceable, saying that the company did not adequately notify the employee about it. And so the result was harsh. However, the appellate court overturned that decision, and they found that the employee had sufficient notice because they had accepted this award, I think about 16 times. And so they had adequate notice about it, and they expressly accepted it via the company's online acceptance procedures. So this is by no means settled in Canada, and so we're going to be stay tuned for any other cases. But some key takeaways here is to make sure that the award agreement specifically draws attention to the termination provisions, and it's not just a cross-reference to the plan. A few other measures that companies can take is to provide a cover memo or cover email, specifically summarizing the termination provisions that are applicable to the employee. And then just going one step further, you can also have the award recipient sign something that expressly says that they've read and acknowledged section X, which is the termination section. So just a few mitigating measures there, and we'll wait to see what else comes out of Canada on this front. Next slide. Another development out of Canada, and I promise this is the last one out of Canada, is that the tax authority there has introduced some new income sourcing rules. And again, just by way of a little bit of background, what that is referring to is how is a particular country going to slice up the income pie, quote unquote, when you have mobile employees moving around, which country gets to tax which portion of the income. The reason this is worth mentioning is that the tax authority in Canada adopted some new rules specifically for restricted stock units, and it's quote unquote a hybrid methodology whereby they're looking at the income in the year of grant that's going to be based on the value of the restricted stock units in the year of grant, and then any gain on top of that is going to be allocated over the vesting period. You may know that in most countries, that's not the typical approach. Typically, you just look at the grant to vest period. And even in Canada, under the US and Canada tax treaty for stock options separately, you're looking at the date of grant to the date of exercise. So that's why these new rules are a little bit different. And the key takeaway here is to ensure that your tax department or your tax folks in Canada are applying the methodology appropriately for restricted stock units. And that way the withholding and reporting is done accurately as well. So, and then China. So we've got a couple updates here. There's been a lot going on in China. I'll just take a step back here and give some background. Typically in China, if a company wants to offer stock-based equity awards to the domestic individuals working in China, there are some onerous application requirements. You have to get approval from the Exchange Control Authority in China, which is otherwise known as the State Administration of Foreign Exchange. And for short, we call it the SAFE. So on top of getting the approval, which requires a whole host of paperwork, there are ongoing reporting obligations that vary depending on the bureau that you receive the SAFE approval from. And there's a lot here, and you guys can look at the slides to get more of the details. I'm just going to touch on a couple of them that, that are important or really stick out. And you'll see as you read through this, most of the changes are to streamline the process to make it more efficient. So one of the requirements, if you received your approval from the Shanghai SAFE, is that you would have to, on an annual basis, go in and do a re-registration of your plans. So every year, annually, it's a more truncated version of the full-blown application, but you would have to do that annually. Recently, I believe in January, the Shanghai SAFE kind of did away with that annual re-registration process. And now they say you only have to go in and re-register if there are any material changes. Of course, it's not clear what material is always, but it's definitely not material if you just have changes to the employees that are receiving the awards. So I think this will help to streamline the process at the SAFE and make it more efficient to get SAFE approval. Another big change came for private companies, I guess you can say. Previously, private companies were not able to go in and get SAFE approval. However, now, if you are a pre-IPO company, so newly public companies, they can go in and consider registration of their IPO plans. So before you go public, you can go in and register your pre-IPO plans, provided that shares, actual company shares, have not been issued yet. So it's okay if grants have been made and you have to disclose those grants to the SAFE, but you just have to make sure that shares have not actually been issued. So this is a big change for China. And I think this will be great for companies to continue to offer the stock-based compensation to employees in China. So other than that, you'll see that there have been some other changes around getting the quota for ESPP. Previously, it was always on an annual basis, and now both the Shanghai SAFE Bureau and the Beijing SAFE Bureau have made some changes on that front. In Shanghai, you can now potentially apply for a quota of up to 3 years. And then in Beijing, we have received updates that you can apply for a quota, and then you don't have to apply again until that quota is used up. So that could be a year and a half or maybe 2 years later. So we are seeing some changes like this being made to hopefully streamline the application process and maintenance process with the SAFE and create more efficiencies for companies offering their stock-based awards to employees in China. That's all I have, unless anyone else has any questions. I'll hand it over to my colleagues, Aimee and Scott.
Great. Thanks, Tulsi. So Scott and I are going to be speaking to some of the developments in terms of trends and some commonalities that we're seeing. Just going to focus on a few of those. And so we have a nice little graphic here that kind of talks about some of the key points, and we'll kind of walk you through a few of these. So in terms of future of work and equity awards, obviously this is a big expansive topic in terms of what future of work means, and it has a whole lot of implications beyond just talking about equity compensation from a labor law standpoint, immigration, all sorts of aspects, but just kind of focusing on the global share plan piece. During the pandemic, we've been seeing many employees working from different locations. So, maybe from their vacation home in another state or in another country, either out of choice or out of necessity. I've heard of plenty of people who have ended up getting stuck in a particular country due to borders being closed during the pandemic. And so we have seen, in part out of necessity, some flexibility in remote work. We consider that to be something around remote work arrangements that's going to be here to stay, which raises a whole host of different issues and considerations, both from a US state as well as a country-to-country tax standpoint. There are, as Tulsi had mentioned in the context of Canada, there are special and specific rules and treaties that govern how to apportion equity income if you have employees that move around to different locations over the life of an award. Usually we think about that in the context of expatriate employees on assignment in different jurisdictions, but it also can come up in the context of people just working remotely from home or in another location. So the company may have tax withholding and reporting obligations in multiple jurisdictions, depending upon where an employee is sitting over the life of the award. It can also present some securities law issues, as you generally need to look at the physical location of an individual when you're offering equity awards in order to determine whether or not there are any prospectus or other type of securities filing requirements that would be connected with the offer. And then I would just say, as a takeaway on this point, companies really, as they're developing their new policies around remote work arrangements and kind of future of work, they'll need to be mindful of the potential implications and compliance requirements in connection with granting equity awards to this kind of new population. And so Scott is going to be speaking to the next point.
All right, thanks, Aimee. Yeah, and I'm going to talk about PEO employers and employers of record. And really, this could just be a sub-bullet point of some of what Aimee talked about. You have a number of companies that are either newly public, or maybe they're just not, they don't want to expand quickly into a jurisdiction. So maybe they don't immediately create a legal entity, but they still want to hire employees. They still want to hire some form of employees, but maybe they don't want to engage consultants. So we see a thriving use, I'll say, of hiring PEO employees or employees from employer of record employers. And it's really a trend that we're seeing more on the West Coast, and it's kind of moving across the country, maybe not as relevant to some of the Illinois employers, or maybe it is, but that is something. And it's interesting because with PEO employment, it's not necessarily just looking at the employment aspects. It really goes a lot deeper, especially into equity awards. Aimee mentioned some of the tax withholding and reporting considerations for future of work. That's also very, very relevant for PEO employees. Does the PEO employer, the organization you're hiring, does that organization have the withholding and the reporting obligation? Does the issuer have that obligation? And what happens if someone does not perform their particular responsibility or obligation? A lot goes into that, but it is a nice, easy way to hire or to engage workers in another country. So if that's something that's interesting, we do have a white paper on that and some further information, but definitely a trend to watch out for. And then I'll flip it back to you, Aimee, for the IPO.
All right, thanks. Yeah, we've been seeing a lot of initial public offering IPO activity. It's been booming lately. There are a number of considerations associated with making grants in connection with an IPO and kind of handling awards that may have been outstanding, granted prior to an IPO. Really important to analyze historical practices, mitigate any possible non-compliance. As a company becomes public, certainly going to have a whole lot more scrutiny and exposure and reporting required. Also important to review and plan for strategies that may be affected by the IPO. So for example, there might have been particular securities exemptions that the company was relying on as a privately held company, and you might need to look at new exemptions when you're making offerings in different jurisdictions like Australia, for example. You also may need to look at obtaining exchange control approval, as Tulsi mentioned, for China. Once you're a public company, you can go in and request approval. Also, in anticipation of an IPO, now you're able in China to request approval. So just a couple of items to highlight if you're contemplating an IPO.
Yeah, and I don't think this will shock many people that have been paying attention to financial news in the last couple of years, but SPACs or blank check companies are a very popular growing trend. And actually, maybe the time we put this slide together, also maybe on the downtrend as well. I think they're all dependent on interest rates, of course, and the financial markets and et cetera. But SPACs with respect to equity awards have been a big deal in the last couple of years. Really, it just involves a merger type analysis or a hybrid of an IPO merger analysis. I don't think there are a lot of companies on this discussion today or issuers that this is necessarily relevant to, but just something to highlight for planned trends.
Yeah, in terms of private company tender offers and liquidity programs, we have been seeing a number of those recently, similar to what I've been talking about exhaustively and with some of the IPOs and future of work. I mean, there are tax considerations, how the payments are going to be taxed if there's a premium, whether or not that's going to be treated as employment income or capital gain. Treatment may vary depending upon whether or not an issuer is repurchasing their own shares or it's a third-party tender offer. So just a few highlights in that respect.
And then Narendra already talked a lot about restrictive covenants, but there is a renewed interest. We're seeing it a lot. We're seeing companies ask questions. Of course, Illinois has their new rules, so it's just something that we're seeing on our end. I won't waste your time talking more about that. Narendra already kind of covered the whole gamut, so I'll just go ahead and pass the virtual ball to my colleagues in global immigration and mobility.
Well, thanks, Scott. I will kick us off, I guess, just by saying that immigration really is a critical component of any back to work strategy for 2022 and the future of work. So as travel restrictions have lifted, we've seen really a pent up demand for business travel. But frankly, the logistics of travel remain fairly complicated, whether it is navigating vaccination requirements and testing requirements, just securing appointments for visas at consulates. Additionally, as offices are opening up and really looking to welcome back employees, some of those employees are not so eager to give up some of the flexibility they have enjoyed during COVID with respect to remote working. And so we're going to focus on two specific issues. Number one, we're going to look at business travel in a COVID world. And then we'll also discuss what does immigration compliance look like in a world where remote work really is the rule rather than the exception. And then time permitting, we'll wrap up with a few words about immigration policy under the Biden administration and maybe things to look for in the coming year. So with that, I'll turn it over to my colleague, John Foerster. John, I think you're still on mute.
Great. All right. So like I was saying when I was on mute, we're going to kick off this first section of the discussion on the immigration front with another polling question about whether your company has resumed international business travel for employees. And while the polling is ongoing, I just want to talk about the current state of the restrictions on travel for individuals coming into the United States. So As of November 8th, the US lifted the COVID-19 related travel restrictions for fully vaccinated foreign travelers, which was great news. And now the new rules are much more straightforward, and they're focused more on the vaccination status of non-citizens. So individuals who have been fully vaccinated, which for most vaccinations is 2 weeks after, timing would be 2 weeks after their the second dose of the vaccine. And there are only there are specific vaccines that are required or that are permitted under the new rules, which I'll talk about in a second. But just to look at the polling results, it looks like there are a good number of companies who have begun international business travel again, and then a good number that haven't, and some others too. So interesting results on that poll question. We can move on to the next slide, though, talking again about the vaccine requirement, the rule that just went into effect. So like I said, the new rule focuses on the vaccination status of non-citizen travelers. There are certain vaccines that are permitted under the rules, mainly the vaccines that are accepted here in the United States and those that have been approved under the World Health Organization's emergency authorization. Now, with the relaxation of the travel rules, there are still other restrictions to consider. So most U.S. consulates and embassies are not at normal capacity for visa processing. What that means is that there are backlogs in appointments, and most travelers from outside the United States who aren't U.S. citizens or permanent residents will need an actual visa to enter the United States. So even though the rules have been restricted, there can still be backlogs when scheduling those visa appointments for individuals who need visas to enter the United States. The expedited or emergency requests may be necessary for individuals who are trying to travel and obtain visa appointments over the holiday months. And each consulate and embassy has a particular way for applying for an emergency or expedited request. So I recommend, if you are looking to take advantage of an expedited or emergency request, to look at the specific rules of each consulate and embassy that you're looking to apply from. Moving on to the next slide, continue to talk about the COVID-related travel restrictions. With the new restrictions, the new policy focusing on the vaccination state, there are a number of exceptions to the vaccine requirements. And in some circumstances, unvaccinated non-citizens who are exempt or receive an exemption must follow specific requirements while they're in the United States. Things like social distancing, reporting, different things like that. In addition, non-citizens must agree to comply with applicable public health precautions, which currently include proof of a negative pre-departure COVID-19 test within 1 day before travel, and also may include proof of having arranged to self-quarantine or self-isolate after arriving in the United States. Now, all the changes from November 8th went into effect before we've had the wonderful surprise of the Omicron variant of COVID-19. And as the Omicron variant has continued to spread and affect more countries, the United States has begun to impose additional travel restrictions. So on November 28th, the US implemented travel restrictions on 8 African countries for individuals who have been in these countries within the 14 days before entry to the United States due to the Omicron variant. This is kind of similar to the rules that were in place before the relaxation of the rules and the focus on the vaccination status on November 8th. But at least for the time being, is limited to just these 8 African countries. And as before, citizens and lawful permanent residents in the US and then certain family members and other individuals who meet certain exceptions are permitted to enter the United States. They would need to provide a negative COVID-19 test taken within 1 day of their departure to the United States, which is also now the standard for air travel into the United States. And there are, like before, other exemptions to the travel restrictions. But this is kind of the first response that we've seen to the Omicron variant, and it's spread throughout the world. So it is possible that additional precautionary measures could be taken as variant in the situation around the world changes in regards to COVID. Can we go to the next slide, please? So in addition to those country-specific requirements, as I said, as of December 8th, December 6th, all international air travels inbound to the United States who are over the age of 2 are required to show proof of a negative COVID-19 viral test that's taken within 1 day of their departure to the United States, regardless of vaccination status. It applies to all US citizens, permanent residents, non-citizens, and foreign nationals. Now, one exception to this testing requirement is that passengers who have had COVID within the last 90 days can provide proof that they have tested positive and recovered from COVID to avoid having that testing requirement. They must have a letter from a licensed healthcare provider or public health official that states that they've had COVID, recovered, and that they are now allowed to travel. And that allows them to not have to be subject to that testing requirement. So now looking outside the United States, so with Omicron and with all these different, the kind of way things have been in the world recently, where can United States citizens actually travel now? So most of the world's countries are open to travelers from the United States, but that can change and might change in the future as variants, including Omicron, continue to cause coronavirus cases around the world to rise. So recently, Morocco and Israel have sealed their borders to foreign travelers due to the Omicron variant to contain the spread. And as things stand now, most EU's countries do allow vaccinated US citizens to enter the European Union, but member countries are free to impose their own restrictions, and partial and full lockdowns have been put in effect in many countries already. Next slide, please. And then looking a little closer to home, specifically in regards to Canada and Mexico. Canada is currently open to US citizens and permanent residents who currently reside in the US if they have proof of full vaccination. Mexico is open to US visitors both by air and land with no testing or quarantine requirement. Now, specifically for Canada, there are rules that US citizens and permanent residents need to follow when entering Canada. They're listed here. You have to have proof of a negative test. Unvaccinated visitors must quarantine, and then there's specific rules that must be followed within the Arrive Canada app. If we can go on to the next slide real quick, just talking about what does this all mean essentially for business travel for employees. So the kind of two big takeaways: one, plan in advance and research the rules upon arrival and departure. All employees should always look closely at the laws of each jurisdiction for where their employees are traveling to and from, because all countries have different health and safety requirements, and these requirements change rapidly, and they can also vary depending on the region that the individual is traveling to within a specific country. Another consideration, what about vaccine passports? They may help, but can you require them? Some countries do have helpful tools that make it easier for vaccinated employees to travel, but it's always important to make sure that you check with the laws of the jurisdiction where you have employees, because many countries outside the United States and also some US states allow employers to recommend but not require vaccine passports. So it's always important to make sure that you check the laws to make sure that you're in full compliance. And with that, I will turn over to our next speaker, Matt Gorman.
Thanks, John. All right, I'm going to talk about immigration considerations. Workplace. Next slide, please. I know we're short on time, so I'll try and keep it brief. So the first big topic to discuss is every in-house counselor HR rep's favorite topic in the immigration space: I-9 compliance. So in the pre-pandemic world, the form I-9 is the form that probably everybody on this call has filled out at some point. All U.S. employers are required to maintain and have their new hires complete this form to verify their U.S. work authorization. Now, in the pre-pandemic world, the new hire was required to bring their original documents in person on day one, show them to employer. Employer was to review them to make sure they were legitimate in completing the form. Now, of course, that was not possible to do in most workplaces over the course of the pandemic, given that folks were not coming into the office. And sort of surprisingly, ICE, Immigration Customs Enforcement, did issue flexible guidance that allowed for new hires over the course of the pandemic to be onboarded remotely for purposes of completing the Form I-9, so they could do it over a Zoom or send copies of their documents to HR or to the employer for verification. Important to note that during the life of this policy, this really only applies if your office is not generally speaking open or there's not a mandate for folks to be there. So if you're a manufacturing facility and you've been open the whole time, you were never allowed to take advantage of this flexible guidance. Now, the guidance has sort of been extended in 2 or 3 month increments, and ICE is doing this thing where they're doing it like the day before it expires. They're extending it for a few more months. So currently, this flexible guidance is slated to expire the end of the year, so the end of this month. There's been lots of calls on ICE to extend the policy for perhaps up to another 6 months. We will see if that happens or not. Again, it very well may happen a day or two before. Now, 2 really important considerations for employers that will create a large burden in terms of I-9 compliance as offices start to reopen. So number 1, either when the flexible guidance expires, so let's say ICE decides to not push it beyond December 34th, or whenever your office reopens, and that idea of office reopening for I-9 in the context of this I-9 guidance is not super clear. But what the guidance tells us is when employees are predictably or reliably in the office, employers can no longer take advantage of the flexible guidance, even if it continues to exist. And again, for 2 reasons, this is important. 1, once you can no longer onboard folks remotely, on a moving forward basis, employers are going to have to revert back to that old school, having folks come in on day 1, making sure the HR person's there, reviewing the original documents. And then number 2, pretty massive undertaking to determine who is hired and onboarded pursuant to this flexible guidance where the actual original documents were not reviewed, and then making sure that within 3 days of reopening or of the flexible guidance expiring, that HR or somebody within the company is reviewing the original documents, even for those people who have already completed the I-9 remotely. Next slide, please. I'm going to talk about that in a little bit more detail. So really high level, 5 steps for reopening and making sure that you are re-verifying those documents for I-9 purposes. 5 steps. Number 1, just getting your hands around the employee population. So your company may have multiple work sites, and determining who was hired and where can be a big task. So that's number 1. Number 2, create a plan across your work sites. It might not be a one size fits all to make sure when are people going to be in the office, when can your HR rep be there, making sure that folks are scheduling appointments within that 3-day window. Number 3 and 4 are really both the same idea: communication. Communicate to your HR team or whoever's responsible for I-9 compliance. This is going to be a big deal if you've had a lot of hires over the course of the pandemic. And then, of course, making sure you have a clear communication to the affected employees who are going to need to come into the office, are going to need to bring their documents. So making sure you have that communication ready to go and in advance of that return to work. And then finally, I sort of alluded to it earlier, categorize the employee population by work site, business unit, office reintegration date. So it's not a one size fit all. You may have one site that's a manufacturing facility. You might have another that's corporate. You might have different timing or different rules for both. Next slide, please. Last few points on I-9 compliance. So, 1, is there going to be a change in USCIS policy? I certainly hope so. It seems like it's an overly reasonable thing to happen for ICE, so I don't know that it will. So for purposes of planning for our clients, we're assuming that the policy, eventually will revert back to old school, having to review everything in person. But there's always the possibility under this administration that there could be a change in policy more broadly. For remote workers in the future, so let's say we're in the middle of next year, God willing, COVID's in a much better place, and folks are, most offices are back, and whatever back means for that office. There are still going to be, a volume of remote workers who, are hired in Utah, even though the office is in Chicago. And in that circumstance, unless ICE changes their I-9 policy, there's really only 3 options to onboarding that person. 1 is flying them in, having them complete the I-9. 2 is sending their documents in the mail, which gives me a little bit of anxiety. Or 3 is designating a third party to complete the I-9 on behalf of the employer. That is a risky option in that the company inherits any liabilities or mistakes that third party committed in completing the Form I-9. Next slide, please. Okay, so really quick on some sort of visa-specific ideas for our considerations for remote work. For the most part, most work visas allow for some level of flexibility for folks moving or working from home, not in the office. The one very specific exception to that is the H-1B. And the H-1B visa has a Department of Labor component of it. It's known as the labor condition application. In that filing, the employer is representing to DOL how, where this person specifically is going to be, how much they're being paid, and whether or not that meets the prevailing wage for that occupation in that location. So in that regard, the H-1B is very location specific. Next slide, please. Okay, so let's give the hypothetical scenario. I'm going to use myself. I'm actually an associate in our DC office, and let's say that I've decided to tell Baker McKenzie, you know what, I want to work from home over the course of the pandemic, or really on a moving forward basis, I'd like to work from home, and I'm on an H-1B visa. Well, this could go one of two ways, and the facts are going to dictate what the employer needs to do. Number one is I live in DC and I'm close by, and I'm just working from home rather than going into the office. Not really a huge deal. A couple of small actions that need to be taken, by me, but the employer is not required to file a whole new H-1B visa petition with the government. In scenario two, I want to go, I'm going to work from my parents' house in Boston, and clearly not within normal commuting distance or the same metropolitan statistical area that was listed in the H-1B. In that circumstance, employers are required to proactively file an amended H-1B petition to list that new work site and verify that it meets the prevailing wage. Next slide, please. Okay, so two last points on the H-1B. So number one, using my Boston example, let's pretend I was working in rural Georgia and my salary met the prevailing wage for whatever that county in rural Georgia was. If I then want to go move to Boston, that prevailing wage might be significantly higher. So there's no guarantee that my wage is going to meet the requirement for the new location. So in other words, it's not always an automatic that this is going to work and that the company is going to be able to fix the problem of trying to work from a higher wage jurisdiction. And then number two, sort of on the flip side of that, employers need to be careful of not affording visa holders the same opportunities that it would for all other employees for wage-related issues relating to the H-1B. So employers just need to be really, really careful and try and craft policies and solutions that apply evenly to visa holders and foreign nationals and the rest of their employee population. Next slide, please. Okay, final topic, and I'm going to speed through it, is this concept of digital nomads. So really, folks working from anywhere, maybe not any one specific place, not one specific jurisdiction, but maybe they're going to travel around a bit and, given many possibilities for remote working, they're going to work from a coffee shop in one country or city. They're going to work from a hotel or an Airbnb somewhere else. Well, really important to remember that as a general rule, working in, I'm going to use a random country, France, as on a visitor visa, but performing substantive work for Baker McKenzie in the United States is generally not allowed. And that's sort of a common misconception. There are a small number of countries, we list here Spain, Portugal, Bali, and Costa Rica, that do allow US employees to remain in their countries on digital nomad tourist visas while working for their stateside employer. That is definitely the exception to the general rule. So something that employers want to be really, really careful about. Next slide. I think we can skip to the last slide, please, given the time. Okay, Ginger, I'm going to hand it over back to you.
All right, well, thanks. Well, I'll just close us out with sort of some, a few observations I think about, immigration policy under the Biden administration. So, I think really the overriding goal of the Biden administration with respect to immigration policy was to restore some semblance of humanity and reasonableness just to the adjudication process, the enforcement process, et cetera. And I don't think that that's a huge surprise. I think we've seen that play out in a variety of ways over the past year with some of the things that are noted on our slide here. So for example, things like the elimination of biometric requirements for H4 and L2 visa holders. Those are spouses of workers on H1B and L1 visas. This is a rule that created a very dramatic difference and a much longer processing time for the spouse as related to the primary worker. And so by eliminating this rule, it has restored, I think, some of the, sort of the continuity and sort of the stability for the family unit when they're going through that immigration process here. Additionally, more recently, making it easier for, again, spouses who are on H4 visas, E2 dependent visas, or L2 visas to maintain work authorization. And again, just create some greater stability for the family. More recently, we also have seen the withdrawal of the rule that created under Trump's world, created a wage-based selection process for H-1Bs. And this is something that was very concerning because essentially it would make it very difficult for individuals who are being educated in US universities, foreign students educated in US universities, to be able to qualify for H visas upon graduation. So basically created an avenue for for that talent that we have developed in the US, giving them free license to leave because it would make it very difficult for them to stay. And so some of those changes, I think, have under the Biden administration have sort of reversed course of it in a positive way. So I think in the coming year, we're going to still see a bit of a calibration happening. Certainly under the Trump administration, we were very used to seeing very strict adjudications, kind of draconian documentary evidence standards, and a system where no deference was paid to prior decisions made by the Immigration Service based on the same set of facts. So some of that has already calibrated in a positive way. I think for H-1B visas, for example, we've seen a return to reasonableness with respect to documentary evidence standards. That might be a little bit slower in coming, I think, for intra-company transfer visas. So I think we'll still continue to see a little bit of calibration there in the coming year. And I think, of course, there will still be ongoing discussion about H-1B policy and, specifically, what is that right selection process? Now, I don't anticipate that there will be any change, for this year in terms of how H-1B selection is done, but there will definitely be ongoing discussion with respect to, how the Biden administration will, again, try to strike that sense of reasonableness and how H-1Bs are allocated with protecting the interests of US workers. So stay tuned, sure to be lots of interesting things happening on the immigration front. So with that, I think we're about at the end of our time. So I am going to turn it back over to Brian for some closing remarks.
Great. Thanks so much, Ginger. And thanks to everybody for all of the updates. Obviously, we've thrown a lot of information at you guys this afternoon. To the extent that you have any follow-up questions or there's any related additional information that would be helpful to you, please reach out to any of our presenters, and we're happy to support you in any way possible. From a CLE perspective, so for those of you that are looking to collect Illinois CLE, there is nothing further that you need to do. Upon conclusion of the program, we will be sending out your CLE certificate by the ACC chapter, and I think that will be coming your way sometime next week. For those of you that are looking to claim CLE in any of the other states, I'm going to give you a CLE code that you're going to need, and then we will be distributing the required CLE forms upon conclusion of today's program. So the CLE code that you will need to seek that credit is Z as in zebra, K as in Kevin, 881630. Again, that's ZK 881630. So look for the email that will come from our team upon conclusion of the program for that CLE credit. And then finally, as you're leaving today's session, we will be seeking some feedback with a short survey that we would greatly appreciate your help in taking the time. It helps us come up with ideas for these types of programs in the future, and again, would very much appreciate your comments. So with that, again, we would like to thank you for joining us this afternoon. Again, hope the information was helpful, and if there's any follow-up questions, please reach out to our team, and we're happy to lend any support possible. And with that, I will let you go and wish you a great rest of your afternoon. Thanks, everybody.